A few days after the Supreme Court published amended rules for the presidential election petitions, the Law Society of Kenya wants the new regulations revoked. The gazetted amendments state that upon commencement of the hearing of the presidential election petition by the court, the litigants, their advocates, and advocates' agents shall refrain from expressing their opinions on merit, demerit, or predict the outcome of the petition in any matter. Given that the Supreme Court had further warned that a breach to this shall amount to contempt of court, the society now says this might create more disharmony and open up the apex court to further scrutiny and possible ridicule, as well as introduction of contempt proceedings. The LSK further arguing that the provision where a party has no right of appeal reminds them of a painful era in the history of the judiciary that is an antithesis of their current democratic constitutional order. They now urge the Supreme Court to withdraw the amendments within the next 7 days to allow for broader consultations on this issue. Meanwhile, a judgment by Justice Anthony Murima that no court in Kenya shall forthwith accept, register, and in any manner whatsoever deal with any charge sheets not prepared and signed by prosecutors has elicited more reactions after the Office of the Director of Public Prosecutions drafted a template charge sheet that is to be used. Activist Charles Rubio argues that the proposed template is illegal as it fails to comply with the requirements set out in Section 137 of the Criminal Procedure Code.
The ODPP, by signing that charge sheet, they become witnesses. Can a witness again be the person to prosecute?
We are therefore calling upon sobriety in the criminal justice system. This issue of coming up with guidelines and coming up with documents haphazardly without consulting and without even proper due regard to process is going to injure public interest in the long run.
Find fault in the manner, in the content first of the proposed template charge sheet that has been proposed by the Office of the Director of Public Prosecutions. And secondly, we also fault it for falling out of form or the required form that is prescribed under the Criminal Procedure Code.
In a petition filed in court, the activist has faulted the logo used, the jumbled up process from the previous system, and lack of public participation in the formulation of the template. Serafina Robi for Prime Edition.